How crazy do you have to beat a murder rap? In the United States, insanity is not a medical condition, it's a legal status. To understand this and answer our question, we have to go back nearly 500 years in American history to 1638. In that year, Dorothy Talby lived in the Puritan Massachusetts Bay Colony, where she fell into a deep depression and disobeyed her husband. As her punishment, she was tied to a post in the public square and publicly humiliated until she changed her behavior. Once she was released, God spoke to her and told her to murder her 2-year-old daughter. She obeyed. Though she was believed to be possessed by Satan, she was nevertheless tried for murder, convicted, and publicly hanged. She did not go quietly as was the custom. Instead, she kicked and screamed and grabbed for the ladder to try to save herself, all to no avail. In the Massachusetts Bay Colony, there was no such thing as insanity, and there was no insanity defense. There was only possession by the devil, and that did not excuse criminal conduct. Over the next 150 years, America and Europe threw people deemed lunatics into special hospitals, along with the disabled, the undeserved poor, the idle, and other social deviants. Although they were called hospitals, they were punitive in nature and doled out punishments including boiling water, acids intended to raise large blisters, bloodletting, and other horrors, all designed to alter the behavior of the lunatics and other inmates. These hospitals proliferated as they were big business. Then, in 1843, a scandalous, good-for-nothing, womanizing lawyer named Alexander Cockburn made his name by asserting insanity as a defense to his client's murder. During the trial, he read extensively from a recently published book by an American psychiatrist, Isaac Ray, who posited that insanity is a disease of the brain and that truly insane people were not sufficiently in control of their own conduct to be responsible for their crimes. Neither idea was new. Long ago, the ancient Greeks recognized that madness was a disease of the body and that insanity could be a defense to crime. However, Cockburn's presentation was so dramatic and so persuasive that not only did he get his client acquitted, but he cemented the idea of the insanity defense into modern law. Cockburn went on to become the Queen's lawyer and have a very successful, albeit scandalous, career. Today, we recognize that mental illness is a disease of the body just like any other illness. In most of the United States, insanity can be a defense to crime. And that brings us to the question at hand. When exactly is a person insane? How is insanity determined? Modern medicine does not recognize any condition called insanity. Instead, that's something the defendant must prove at trial. The evidence goes something like this. Witnesses take the stand and describe bizarre behavior of the defendant leading up to the crime. Then medical experts take the stand and discuss the defendant's mental state. They discuss it in terms of medical diagnoses, and a condition often diagnosed is schizophrenia, although many other conditions have been offered to the jury as proof of insanity. The doctors are not allowed to testify with respect to whether the defendant should or should not be held responsible for his criminal conduct. Then the jury has to answer the question whether the defendant is legally insane. The specific question they are usually asked is whether the defendant had the capacity to understand right from wrong. A defense related to insanity is the so-called Twinkie Defense. In a 1979 trial, evidence showed that former police officer Dan White murdered San Francisco City Supervisor Harvey Milk and Mayor George Moscone. In his defense, White's attorney argued that he had diminished capacity because he had changed his diet from healthy food to Twinkies. The attorney argued that the change in diet affected his mind the same way as any other mental illness, and it should be an excuse for his criminal conduct. The jury was allowed to hear the same kind of evidence they heard in any other insanity defense case. Facts about the bizarre behavior of the defendant leading up to commission of the crime, and then medical testimony about the effect of this change in diet on the defendant's mental state. The jury bought the argument at least partially and convicted White of only involuntary manslaughter, which was the most lenient charge available. This led to public rioting in San Francisco and important political changes. 4 states do not recognize the insanity defense. Yet even in those states, the defendant is entitled to argue that there was no criminal intent because of insanity. Today, defendants rarely use the insanity defense for these simple reasons. In order to invoke the insanity defense, the defendant must admit to doing the criminal conduct. That means if the jury does not buy the insanity defense, the defendant is automatically guilty of the crime. In addition, even if the jury does buy the insanity defense, the defendant does not normally go home. Instead, the defendant faces civil commitment proceedings and is often institutionalized, sometimes for much longer than the defendant would have served in regular jail time. I'm your host, Jon Deer. You can find us here each week at BlobLaw.com. Be sure to like and share our Facebook page and mostly subscribe to this YouTube channel. We'll see you next week right here on BlobLaw.